Welcome back. A recent incident in Manatee County was news to many folks. A teenager arrested for allegedly having a gun on a school bus has a prior felony conviction, and it begs some obvious questions. How many teens with felonies are roaming school hallways, and do parents have the right to know if it is safe, and what would be the alternative? Joining us for more is Michael Barfield of the American Civil Liberties Union and Assistant State's Attorney Nicole Jones, who handles juvenile justice cases in the 12th Judicial Circuit. Welcome to you both. And Michael, let me start with you, because the obvious question for a lot of folks would be asking, especially if they are parents with kids in high schools, is, they would want to know if there are other kids roaming the hallways with their kids who have serious felony charges or convictions against them, because they want to know that their kids are safe. To which you say?
Well, I think that transparency is always a good thing, but I think we also have to look at how easy it is to become accused or convicted of a felony as a juvenile in the state of Florida. In my opinion, we over-criminalize very minor offenses at the juvenile level, and the consequence is that it's very easy for a kid to pick up a criminal charge these days under a variety of new statutes and old ones.
Right, but I mean, there's a difference between a conviction for, let's say, a drug crime and a weapons charge, or a burglary, or an assault and battery, and I guess that's what people might be concerned about.
Well, in those situations, there are alternatives that exist for kids that are accused of crimes, and of course they're entitled to due process. We don't presume that they're guilty, just like when you or I, if we were charged with a crime. But as far as the other parents' right to know whether there is someone that's convicted or adjudicated of a felony, I think that that's something that the legislature should address, because as I understand it now, if you're charged as a juvenile in Florida, that information is publicly available. Now, if it's a misdemeanor, the answer is no. But if it's a felony, that information is not exempt for a juvenile.
Nicole, what is the difference with a teenager being charged with a felony in the Florida courts as opposed as an adult, in terms of the dissemination of information and what is not public record?
For a felony for juveniles, as Michael had said, that the information is public. Certain information is public. So their photo is available if posted, their name, their address, and the type of crime if it is a felony. Most news agencies or schools don't provide the information, but it is available if they wanted to provide that. Is
there a routine that if a child or a teenager is charged or convicted of a felony, that it's automatically disseminated to the school district?
Yes, there's actually a statute that the clerk is supposed to notify the school board about a child's felony record. That way the school does have information about that youth.
And Michael, is it up to the discretion of the school district how they want to handle it, whether they keep that child in the student population or they move them into alternative programs like you saw in Justice Story?
Well, there are certain statutes that the legislature has prescribed that if you're convicted of certain offenses, that the school district must take the child out of that school and put them in an alternative school. That's been expanded. Every year we seem to get a new bill from the legislature of how to deal with juvenile crime. But to me, the underlying problem is that there are always the isolated cases that skew our focus and attention. And to me, it's the over-criminalization in juvenile courts that we need to address. We're going to talk
about that some more. We're going to just getting warmed up, and we'll have more on felons in schools right after we check the first alert weather. Stay with us. Welcome back. We are talking about juvenile offenders in the schools, and joining us for more is Michael Barfield of the American Civil Liberties Union and Assistant State's Attorney Nicole Jones, who handles juvenile justice cases in the 12th Judicial Circuit. Michael, let me start with you again, because in Justice Story we talked about the alternative programs out there, and the flip side of the argument is that some people might think that those those alternative programs, especially if you're lumping all these kids who, for one reason or another, have these criminal convictions or charges against them, that they're not getting a great education or educational environment in those programs?
Well, first of all, to get into Triad, you don't have to have a criminal offense at all or charge. You can be sent there for being truant, skipping school. I think that's an exaggerated response to truancy, because it does take that kid and puts them in with people who are convicted or adjudicated of crimes. And if they go to a detention facility, that's the part of what we're trying to avoid, I think, is exposing children who make a mistake of stealing something from Macy's or whatever, shoplifting, exposing them to someone of a more hardened character. And our system that we have of juvenile justice in Florida does a terrible job at separating those kids from that category.
You know, Nicole, some of this is public policy, but as a prosecutor who sees these cases on a daily basis and deals firsthand with the range here of minor offenses, and obviously no felonies are not all alike, what would you like to see in terms of happening to these children while they're awaiting the charges going through the system, or after they're convicted of it?
Now, I think depending on the nature of the charge, depending on the type of felony, whether it's a theft from Macy's versus a home invasion robbery, I think the schools are trying to take it as a case-by-case basis and not necessarily kicking students out of their home school or their main school upon first glance at it. So they've been trying, depending on the crime, waiting to an outcome has actually happened in the court. So waiting for a conviction to happen first before they remove them from the environment, unless it's a serious felony, such as a home invasion robbery. But for thefts and such, they wait until there's an outcome. And even then, they meet with the youth and the parent and the school board, and they have a meeting amongst themselves to see if the youth should be transferred to the alternative school. So there's some instances where they're not, where they can have a felony conviction or adjudication and remain in their home school depending on what type of felony it is. So they're given some type of settlement agreement. Not violent, correct.
Okay. You know, you see this on a daily basis, and I would imagine that you run into teenagers who made stupid mistakes, but you also observe almost the circular door and young people falling into a system and getting basically deeper into it. Do you have any insight in terms of how do you stop that from happening when you see a particular individual going in the wrong direction?
We try in our county, and all juveniles should be handled this way, to rehabilitate. So we try, when they first come in the system, to divert them. So they're given an alternative to actually having an adjudication on their record. Counseling services, family counseling, substance abuse programs. So we tried to provide as much resources as possible. The Department of Juvenile Justice finds programs for them where they can start out not having a history, depending on the crime again. We even divert some type of felonies to where they wouldn't have a conviction, so it doesn't ruin their life.
Non-violent felonies.
Correct, non-violent felonies.
You know, Michael, you brought up the issue when we were in the break of prolific offenders. It's a new law, a fairly new law, that was passed by the legislature this year. What does that mean in terms of young people who are labeled that and their ability to stay in school or be in school with, you know, a lot of the kids out there?
Well, a juvenile who accumulates a number of offenses, and it does not have to be violent, they can be nonviolent offenses. If they rack up 5 shoplifting offenses, they could actually qualify as a prolific offender under the new statute. But, you know, I'm going to go back to one point that Nicole brought up. Pre-arrest diversion, the recidivism rate for kids that go into a pre-arrest diversion is the lowest of all categories. Yet only 55% of the kids in Florida that are eligible for that receive pre-arrest diversion, we have a lack of opportunities of programs and bed space in non-secure facilities to serve the needs of these kids who do run afoul of the law. And we send 100 kids a month to state prison in Florida, juveniles, 100 a month.
I want to get back to my original question, but Nicole, is that a matter of resources?
It is a matter of resources. There are pre-trial diversions, pre-arrest diversions, but there are also diversions after they've been arrested. So there's a couple of bites at the apple, and I know that some of the laws have changed with civil citation in place where they get multiple chances to do a pre-arrest diversion.
Okay, now getting back to prolific offenders, what does that law mean in terms of their ability to go back to school or what their eventual sentence is?
Well, they definitely would not go back to school if they're adjudicated or even, I think, charged with a prolific offender.
Even though it may be a nonviolent offense?
I've heard there's only one in Sarasota County, and I don't know what the circumstances of whether it's nonviolent or violent or a combination of all of the above.
Right. So, Nicole, if you have a situation like that, what does that mean for the child and their ability to get an education, or, you know, parents knowing that a child like that is not in their kid's school?
Well, a child that would qualify for a prolific offender has a lengthy history, definitely consisting of multiple felonies. So he would be probably kicked out of the mainstream school and placed in the alternative school.
Okay, we have to take a quick break, and we'll be back for final thoughts in a moment. And our guests join us right now for final thoughts. So, Nicole, talk for a moment to the parents out there right now who, you know, they heard about the story a couple months ago. They hear that under certain circumstances, felons can be walking the same hallways as their kids in school, and it just makes people upset.
It would. I guess the biggest thing that parents probably need to do is have conversations with their kids. You know, that's lacking nowadays, where they sit down and actually discuss issues with your child. Or are they fearful if that child found out that someone else was in their school with a felony? Maybe the child would be fearful, maybe they wouldn't. I think the biggest thing that parents need to do at this point is speak with their kids about what's going on in class, about other kids in class, and how that makes their child feel, and whether or not they would want someone to go to an alternative school or not.
But I'll tell you what, Michael, having two kids who recently graduated high school, I know what they said to me about some of the folks that they went to school with, and they may not know those kids have real histories of violent offenses or offenses that you would not feel safe about your kid being in the same school with.
Well, I think being aware is one thing, and like Nicole talks about, that at home, the parent talking to the child about it, being aware how that makes them feel, talking to the school to reassure that they're safe. But again, I think that what we're really missing here is that our approach to juvenile justice in Florida has failed. Our direct file mechanisms that takes the discretion away from a judge, that kids go right into adult court, is atrocious. If you're a special needs kid, that you're 7 times more likely to be arrested. It's so easy to get that designation of a felony adjudication in Florida, and that's a legislative problem. It's not a...
We'll have to leave it there. But before we go, we want to share with you what some of you had to say about last night's show on security at places of worship. Last month, 26 people were killed by a former airman with a history of mental health issues as they prayed on a Sunday morning at their Texas church. In 2015, 9 people were killed by a white supremacist, Dylan Roof, at a church in Charleston. Synagogues and Jewish community centers have had to constantly deal with bomb threats and defacement. So have mosques, including one in Tampa, where an arson fire caused damage last year. So is increased security, including training pastors in how to deal with mass shootings, the answer? Matthew says, wonderful society we have built for ourselves. And Mary says, in most churches, the pastor or priest is facing the congregation and can see if anyone enters the doors. Maybe they should be required to carry at all times whenever a service is given. Well, if you'd like to join the conversation about tonight's topic, just visit our Facebook page at facebook.com/. youtube.com/mysuncoast.com.abc7. And FYI, you can watch past discussions on demand. They're available on Apple TV, Amazon Fire, and Roku. And a reminder, you can get all the latest local and national news on our smartphone app, but if you are an Apple iOS user and have the old version of our app, it will go away at the end of the month. iPhone users, you can find the new app by searching My Suncoast in the App Store. The app will update automatically for Android users. And we want to thank both our guests for being here tonight. Michael Barfield of the American Civil Liberties Union and Assistant State's Attorney Nicole Jones, who handles juvenile justice cases in the 12th Judicial Circuit.